Hello, welcome to our first legal Q&A for business owners live. We're going to do it every Monday in March of this year. And April, we'll figure it out if the schedule is still good for everybody. If not, we'll make some shift and also make some improvements as well. So stay with me and we'll make a further announcement. So without further ado, let's go into today's topic. Let me pull out my documents. See, this is one of the things that you go live, right? If there's a hiccup, you kind of have to roll with it. Apologize for that. Let me pull out my agenda up really fast. Okay, here you go. See, I want you guys to see the agenda here as well, because focusing on my face, although it's nice, has a human touch, but there are a lot of materials I need to cover as well. So we can all follow along if I share this agenda with you. So welcome first. For those who don't know me and for those who are watching the rebroadcast, my name is Tony Liu and I'm a business attorney here in Orange County, California. And my specialty is really solving legal issues for business owners so they really can focus their time, energy, and money on growing their business, right? So they can make more money and earn more money, keep more for themselves and their family. So that's really my whole objective. Now, first thing first, this legal Q&A is to educate and to provide general information. And before you rely on the information that presented here, you should consult with the attorney. Let me tell you why. Information will create awareness for you, okay? Where the information become the solution for your situation is you take your facts and the information that we presented here or in the future Q&A and merge them together and do an analysis. And that's where you will come up with a solution. And generally, you need to talk to an attorney when you do this particular analysis with facts and it all. So that's why I always recommend before you take any action, always consult with the attorney. If you are interested in establish attorney-client relationship with our firm, please give us a call after Q&A. We love to talk to you about the possibility of being hired as your company's general counsel. Now, first question. I terminated the business relationship with a sales representative, and now he's competing with me by getting the goods from the same manufacturer overseas and sell them to our customers. What are my options? This is really loaded with a lot of questions, okay? So let's take one step at a time. Let me get a notepad out. First of all, you really need to take out a contract that you sign with this sales rep, okay? Now, I'm just use the short term sales rep, but you know what I mean, right? Sales representative. You need to get a contract out and to read them in detail and make sure you understand the rights and responsibilities of each party at this particular time. And if you are planning for termination, you need to read up on it as well, see what steps that you need to do in order to terminate this particular relationship. Now, I want you to be very careful though. You need to know what's the relationship between your company and this person. Is the relationship truly the independent contractor or the sales, what the industry called manufacturer's representative, or this person is really your employee? Now, if this sales rep is your employee, then I want you to tread really carefully, right? Because there are certain things that you can or cannot say to a third party because of the privacy issue. And there are certain things that you should or should not say to a third party to prevent got involved in unnecessary lawsuits. Okay, and in the event of fight, the court fight, you don't want to be dragged on with the employment issue, because in California, the labor law is favored on the employee. So if this person is an employee, you should talk to your attorney and tread really, really carefully and come up with a strategy what you're going to do. Now, if this person is the independent contractor or manufacturer sales rep, where he or she has his, the own company operating under a separate entity, they have their business location, they have their own business telephone number, they represent more business, you're not the only clients of theirs, things like that. If they are truly the manufacturer representative selling the goods for you, then there's certain things that you can do. Okay, you can take a little bit more assertive approach on this. I will, number one, you got to read out your contract and understand your rights and responsibilities and theirs as well. Second, you can approach this manufacturer and talk to them about the situation in a diplomatic way. Okay, generally speaking, this supplier or manufacturer or the customers, they don't want to get in trouble. Unfortunately, they don't care about where they buy the goods from, right? If they have a better relationship with this person, then most likely they will buy from them. If you have developed a strong relationship with this customer, then not only they will buy from you, but they might also tell you, what's the other person is up to. So it depends on the relationship that you have with these customers. Okay. Sometimes the issues can be addressed there. Sometimes, I have seen some situation where this manufacturer representative is really assertive. They are just keep on going, right? With same customer, same manufacturer. So what do we do about that? Well, that is a point number 3. Okay. It's my firm belief that you need to solve the situation based on a business solution first before you employ your legal options, okay, or go to court. Okay, you can consult with the attorneys while you negotiate, try to solve the issues with them out of court. I'm all for it. I think that's the best approach. And if there's nothing can be done, obviously, if that legal option is only things available for you, then you have no choice but go forward with lawsuit. But I'll say that for point number 3. Now, the next question the most question you need to ask, and I have on this agenda here, you need really to do a risk and benefit analysis. Okay, take the emotion out, take the ego out. And I know in this situation, you will get really mad. How can he or she do this to me? I treat them really well. They go around me and stab me in the back. It might be true, but that doesn't help you out in terms of solving the situation, okay? Or that will not help when you do the evaluation. Most of the time, you will complicate it, okay? And it's good to have somebody like your attorney to look through the situation with third party's point of view. See, if you call my office and if you have this situation, I'll tell you what a third party's perspective on this situation, especially on the risk and benefit, right? The risk means if you want to pursue this person legally in court versus how much damage you can receive back, okay? whether or not there's a significant difference, or you're probably going to spend more money on legal fees but not going to recover a whole lot. That's something that you need to evaluate. And if you call our office, we will give you a third-party perspective on it. Okay, it's really hard when you are the first person or you're the person involved, because with that emotion and ego, and I totally understand that. But for this particular Q&A, I just need to let you know, let ego and emotion out of the business reality. Okay, and the business reality to a third party is if you pursue this person in court versus the benefit you're going to get back, the damage you're going to receive back. What's a plus and minus? If the net result is plus, you get more money than you spend in a significant way, then legal options for you. If it's negative, definitely not, right? And if you're only going to receive little bit of recovery, not whole lot, not significant amount, then the next question you should ask yourself is whether or not the time, money, energy, focus, spending on a lawsuit is a worth cost, okay? Because if you spend your focus on a lawsuit, that also means that will take away the same energies, the same focus on growing your business. So that's something that you have to evaluate really carefully. Next question is kind of related to the first one, and I've been asked a lot, is customer list considered as a trade secret? As a business owner, I understand client list, customer list is the most important asset for me and for a lot of business owners, okay? But whether or not they are trade secret that is protected by law, I don't know. I would say most of the customer lists are not, okay? See, the court is really reluctant to recognize the customer list as a trade secret for a number of things, right? Because of this strong public policy that employees or anyone has a right to make a living. And if this person is the employee, he or she can use the general knowledge, skill, or experience that he acquired to make a living. They have that right. Even if the skills, the knowledge and experience was gained or acquired from previous employment. And even though they use the same set of skills, knowledge, and experience to set up a competing business, right? They have a right to make a living. Now, that doesn't mean that they can do whatever they want, but that's just a public policy the court has. They, when they evaluate this kind of situation, they have that in mind, whether or not I'm gonna take the opportunity of make living from this person. So they have to do a balance. Now, the customer list can be protected as a trade secret if you do two things, okay? Number one, if you expend time and effort identifying the customers with particular needs, okay, or characteristics whose identity were not readily ascertainable or is not available in public. Number two, you got to take reasonable steps to maintain the secrecy. Two things the court will look at, okay? Now, what do you mean by, spend some time and effort, identify the customer with particular needs? Okay, let me give you an example. If you just got a list of customers, let's say from Info USA, it's not confidential information. It's not trade secret, unfortunately. Even if you compile information from internet, which is so rarely available these days, they're not a trade secret. However, if you develop that list, if you spend like 3-4 years to develop the list, and every time you talk to the customer, you jot down the information or take notes. In 4-5 years, you have this accumulation of the notes for these customers. That is the first step to turn this list into a trade secret. Okay, the list itself is not a secret, but the information attached to that list, the information attached to that particular customer, that's what makes the list a trade secret. Okay, so let's look at an example. In previous cases, you know, the company can isolate the customers who is going to buy what product, and who are the top, in this case, top 6.5% of the customer is predisposed to buy company's product or certain product. Okay, we know there are a general list of customer to a short list of those who will actually buy what product at what time, at what season. Okay, or the list has the sophisticated information attached to it, like building rate, the key contract that they signed before, special requirements that they need before they will order the goods, and the markup rates, things like that. So list itself is not trade secret. If you have information that you spend time and money on to accumulate, and it's not available in public, that's what makes it list potentially trade secret. And the reason I say potential trade secret is you also need to take steps to make sure to treat this as a secret, right? If you don't treat your customer list as a secret, guess what? The court will not do it as well. If you don't think it's a secret, then why should court consider the list as a secret? It's pretty logical. So what you need to do is you need to advise the employees that certain information is a trade secret, okay? And you need to have limited to access. Put the information in the vault or in locked drawer, things like that. Sign a confidentiality agreement, and have this policy in the employee handbook. What are the trade secret of the company? What are the confidential information of the company? The exact steps that they need to take to preserve that secrecy, and also that just provide, if you have a trade secret, then you provide this employee on a need-to-know basis. Now, the classic example that I always give to my client when they come to my office and explain to them is, the formula for Coca-Cola. It reportedly say only 2 people knows the formula, the original formula for Coca-Cola. I don't know how true is that, whether or not it's more than 2 or just 2, or even it's relevant now, because there are so many kinds that the energy drink seems to be a big surge for recent years. Take a lot of market space, market share for the soft drink market. Now, that's type of the treatment that you need to treat your confidential information, is to protect it, treat it as a secret. Let employee know as on a need basis. Okay, if you do that, then court will realize, hey, if you do that, then the court will treat it as a confidential information as well. Now, generally speaking, is that the more difficult the customer information is to obtain, the more time that you spend on it to develop the additional information that is not known in public, the more resources that you that you spend on the list to compile this information, the more likely that the court will find the information constitute a trade secret. And just on the opposite side, if you just buy a list from Info USA, for example, or you compile from internet or doing the Google search, unfortunately, those lists are not trade secret. Now, if you 4 or 5 years down the road, you compile a lot of information that is not known in public through the personal contact, for example, through some relationship developing, you learn some of this particular facts important for this particular individual client or customer, then that's what the list trade secret. Okay. Question number 3, what can we do to stop them from using the customer list? Okay. What I list here is the legal options that we have. Before we go into that route, I always recommend client to sit down with this person and see if there's a whether or not the issue can be resolved. Okay, take out the emotion, take out the ego, out of discussion, and just sit down and see if there is an opportunity to resolve the issue without court action. Many times, in a business scenario, many times we can resolve the issue. Sometimes you just can't, right? If you know the other side is not forefront with the information, then it's not open or it's not sincere to have discussion, then obviously you need to go to the first next step. Now, assuming that you have done that, and what are the legal options that you have? Well, at that time, you have no choice but file a lawsuit. Then we will seek temporary restraining order or preliminary restraining order. What I mean is that you want to get a court order or injunction from the court before the trial, or before the court has a determination or rendering a judgment on the trial day, which generally is about 1 year later. But you cannot wait that long. You need to have an injunction right now. That's the time that you file a temporary restraining order, or TRO. We generally hear that term, or preliminary injunction. Okay. 2 things that the court will look for is whether or not you need to tell court why you cannot wait for 1 year, why there's an urgency, exigent circumstances, the court call it, why there's an urgency that you need to have such court order to prevent this person from doing certain things, to use your customer list, to approach your vendors, things, or continue to use the company resources that they did not legally take from you. Okay, you need to explain to the court. The second prong is you need to explain to court, if the court doesn't issue the injunction right now, before the trial day, before the court has the opportunity to hear the case from both sides and make that determination, why the court should act. The most scenario, you need to tell court that if the court doesn't act, you're going to be harmed to the point that even you win a lawsuit 1 year later, you will not repair your company. You will not repair the damage. Okay, in legal term we call it irreparable harm. It's not something that can be repaired, even though you win the case 1 year from now. And those two, if you satisfy those 2 prongs, then the court will most likely issue an injunction. So pretty much the injunction is a mini trial in court, through paper, through declaration, through documentary evidence, or if you have a testimony, we just put it on paper as in form of declaration. So it's kind of like a mini trial. Sometimes
if you have a strong document, one hearing is sufficient. If not, if the issue is really complicated, generally the court want to know a little bit more about the case. They will put temporary restraining order first, and then have a several hearings to make sure that court understands what's going on with your case and why the injunction need to be issued. Then the court will issue a issue or deny, I should say, the preliminary injunction until the trial is over. Okay. Now, I don't want to give you expectation that once you file this, you're going to get it. The standard is really high. Judge want to make sure you have those two prongs satisfied, the urgency and also the irreparable harm requirement, because the court doesn't like to stop certain individual from doing something. That's the general thing, unless it affect you and your person. Then that's the time, if court has that certainty, then most likely the injunction will be issued. The more life versus Perry. We use this case a lot. This case is also demonstrate the court's view about injunction and also the customer list and the public policy of right to make living. Okay, so More Life filed a lawsuit against Perry, and they sought an injunction for Perry to stop approaching the customers. Now the court only issued an injunction prohibit defendants from doing business with any of the 32 clients unlawfully solicited from plaintiff, okay? And also prevent them from soliciting any business from or entity with that did business before with More Life, before they left, okay? However, they did not prohibit defendants continuing to engage in business activity with whom that they had no contact with plaintiff and with whom that they did not acquire the information from More Life. So even though they acquired the information from the same customer, but if it's not from More Life, then they're not prohibited from doing so. So from the court's ruling, you can see the court is balancing out between the public policy of right to make a living and also the harms that you're going to suffer in terms of issuing injunction. So that's always something the court will balance it out. Now, especially, this is an interesting point. Generally, the injunction has a time period, right? But this one does not, because the court says, it's not necessary to have such, it's not necessary for injunction to last forever, okay? But will continue if necessary to eliminate the commercial advantage derived from the customer list taken from the former employers. In other words, the court will leave it open for future debate whether or not the injunction should end or continue. So that's also shows the caution side of the court when dealing with the injunction. They want to make sure that they did the right thing for both sides. Okay. Now, the question number 4 is that what is the difference or the benefits between seeking legal advice when the shit hit the fan? Excuse my language, but it is what it is, right? Or have a business attorney acting as a fractional general counsel where you can talk to the general counsel all the time regarding to your issue, okay? The difference is also what depends on your perspective, okay? And it will depend on your perspective, what you think about attorney and what they can do for your business. Years ago, one client of mine jokingly told me that I am his business partner. It's not because I'm the equity partner of his business, but generally I'll get involved in his business, and then he will need to compensate me, right? That's almost like it happens about 7 out of 10 times. So 7 out of 10 business transactions. He always need to get attorney involved, engaged, things like that. So he was jokingly telling me that I was his business partner. Now, if you have that perspective, then it will be easier for you to see the benefit, right? And what we attorney can do to your company's bottom line. If your perspective is oh, hiring an attorney is, there's really no value coming in, but all they do is bill me for a lot of money, and I don't see a whole lot of value received. If you have that perspective, then obviously you're not receptive to all the information. Let me give you an illustration. Okay, I think it's easy for me to show you. Now, in business, we have a lot of risk. Okay, you know that, I know that. The entrepreneur is famously good at taking risk for the future rewards. All right, that's what we live by. That's why we're in business. Now, we always have this risk. Some risk is for economic risk. Some are strictly for legal risk. Some are both legal and economic risk. Some legal risk, they might later turn into the economic risk. And some economic risk will also turn into the legal risk. Now, it's really, at this particular stage, okay, at this particular stage, if you can identify them and eliminate them as much as you can, this is the stage where the cost is very little to eliminate them. Even if they surface up, you can just extinguish them really easily, really fast, with very little impact for your business. So this is the best place for you to have a system to identify the potential risk for your business. And this is where the general counsels are active. This is a general counsel services. That's for us. That's where we've spent a lot of time, is to look at your business, see which one, where are the red flags and potential issues, and what can we do about it, how we can eliminate them, how we can set up a system so that the future occurrence will be minimized, and or set up a system to identify them so we can eliminate them at this particular stage. We are not able to eliminate all the risk, okay? That's impossible. Somehow, it's just not clear at that particular time. For one reason or the other, we don't see it, we didn't realize it. That happens all the time. For this, sometimes they will take it to the next level, okay? At this particular stage, when you already know, when this risk already tend to the issue, the problem, you can still deal with it. It is particular, obviously the cost is going to increase. There's probably going to be a little bit more consequences, positive or negative, depends which side you're on, to resolve the issue. But the cost-wise will be more expensive than when you are at a stage one. All right, this is stage one. This is stage two and stage three. Stage three is where the lawsuit that you need to file, you need to go legal. And you have no choice but to do that. But at stage two, I still highly recommend, if you can, to resolve the issue in this particular stage, do it. Do it. It will make a lot of business sense for doing that. The impact might be manageable. The cost will be higher, but still manageable. We can learn from it still. The cost will be higher, obviously, but it's still not too late. When you want to go legal, when you want to go court system, 7% of the time you have passed a point of no return. Okay, Meaning, if you want to go legal, you need to prepare that you pass that point. When you pass that point, that means it means a lot of things. It means that the resolution may not be somebody's happy about. Some people might think it's a win-win, but most of the time, I think when you pass this point of no return, the resolution is more like lose-lose, right? I'm sorry to break that to you, but that's pretty much the real stuff, okay? Nobody wins. Very few people win during a lawsuit. Very few. I'm not going to say nobody. Obviously, somebody did you wrong. You want to go to court and seek justice and recover your harm or your damage. There are cases like that. But most of the time, if you pass that point of no return, I think I can comfortably say most likely it's a lose-lose situation. It will also depends who's gonna lose less and who's gonna lose more. Okay, I think that's pretty much a better perspective. The business might not be when business pass that point of no return, it might not survive. Okay, on the phase 2, there are a lot of things that we can do to still make company profitable and have a few years of business life. When you reach your point 3, we pretty much go red. And in that situation, the focus is on litigation. The focus, the owners might not put 100% of the time in business and make it grow. So in the stage 3, I have seen a lot of business come out of the lawsuit, even though they are ahead compared to the other party. The impact on business is severe. Okay, it takes a few years to rebuild. After the lawsuit, even you settle in stage 3, you can settle it. People move on, but it takes a number of years to repair the company and the business. So that's the comparison I can give you is if you get your attorneys involved in this stage, it's more beneficial if you get your attorneys involved in this stage. And this is a stage, unfortunately, is when the shift hits the fan and anything can happen. The goal is we eliminate as much on stage 1. So only 1 or 2 pass stage 2. Then we eliminate them, okay, as much as possible. If we are not able to eliminate all the risk, and in the event that they have to go to the lawsuit, because so much work has been done in stage 1 and stage 2, even if you engage in a lawsuit, you will gain and get out in a cost-effective manner. And that's the difference, right? When you get your attorney involved in this stage number 3, without 1 or 2, the cost will be higher. It will drain you emotionally, and it will create a lot of stress sometimes. But if you go to stage 1, stage 2, have an attorney involved constantly in that stage, when you have to go to court and file a lawsuit, you can gain and get out in a cost-effective manner. So that's my 10 minutes illustration of benefits of hiring an attorney for your company. And we are about 45 minutes in, and let me make sure that I don't see anybody post questions on the Facebook. And if I'm wrong, I apologize for that. I promise the process will be more smooth next time. All right, there's always room for improvement. If I missed your question, number 1, I apologize for that. Number 2, you can always email me offline and I'll take care of you. Okay, I either answer your questions, let you know the options, or point you to the right direction. So until next time, next Monday, I will see you again in legal Q&A for small business owners, and hopefully you find this beneficial. And Again, welcome the comments. Let me know. Bye.